Good evening, everyone. I, Saquib Rahman, Senior Lecturer at the Department of Law, North South University, would like to welcome you all to our webinar today. It would be an absolute delight for us to be able to listen to Associate Professor Kathleen Claussen, who has very kindly made the time to talk on intersections between trade and labor law. Before we request Professor Kathleen to start, I would like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would like to extend my thanks on behalf of the Department of Law to all of you present here today. Now, regarding our guest speaker, Kathleen Claussen is an associate professor at the Miami University School of Law. Her work has appeared or is forthcoming in the Yale Law Journal, the Stanford Law Review, the Columbia Law Review, and the Virginia Law Review, amongst others, as well as in leading international law journals. Professor Kathleen holds a number of leadership positions within international law and arbitration professional associations. Among other activities, she is the co-chair of the American Society of International Law, International Economic Law Interest Group, a member of the American Society of International Law Executive Council, co-chair of the Junior International Law Scholars Association, and serves on the Academic Council of the Institute for Transnational Arbitration. Recently, she has been appointed co-editor-in-chief of the Journal of International Economic Law. Earlier in her career, Professor Kathleen was legal counsel at the Permanent Court of Arbitration in The Hague, where she advised on disputes between countries and on investment and commercial arbitrations involving countries and international organizations. Before listening to Professor Kathleen, I would like to request Professor Mohammad Rizwanul Islam, Chair of the Department of Law at North South University, for his introductory remarks. Please.
Thank you, Saquib, for your introduction to our honorable speaker for this evening. The audience, good morning or good afternoon, depending on wherever in the world you are. It is my utmost pleasure and privilege to say a few words about today's topic. First of all, I would like to thank Professor Kathleen Claussen to generously agree to speak at our webinar series. Now, the interaction between trade and labor law has been one of the most contested arenas of international trade law in last couple of decades. On the one side, there are mainly developed economies who would argue that labor rights are not merely issues which are best addressed only in the ILO or between the WTO domain. On the other side, there are many in the developing world who have traditionally argued that labor rights are issues that are best addressed at the International Labour Organization. This is not necessarily a trade law issue, and this is not something that the WTO should address. And in the Singapore Ministerial, there was some sort of a consensus, not a very firm consensus, I must say, but nonetheless a form of statement that some of the non-trade issues like labor would not really form a core part of WTO negotiations. But nonetheless, at various points of time, this debate has resurfaced. This continues to be an issue in international trade and economic area. And this is an issue that has affected our very own country, our Bangladesh, because when the United States a couple of years ago, when its GSP scheme was still operational, they took Bangladesh off the list of countries which were eligible for GSP. And the principal reason that the USTR cited was that there were some labor rights and labor safety issues in our garment industry. Although, ironically, our garment products were not enjoying GSP benefit in the US. So there are many in this country who are not particularly sure that the argument that the US really used for its GSP withdrawal, was it really something true, or were there other factors that were at play here. So I'm sure our today's speaker would talk about these issues, and I look forward to the talk. I look forward to your questions. Thank you all for your time.
Thank you very much, sir. Now the talk that you've all been waiting for, Professor Kathleen, whenever you're comfortable. Thank you.
Great. Well, thank you so much, Saquib. Thank you, Rizwan, for the generous invitation to be a part of this distinguished series. I'm honored to be here to share some thoughts with you about, as you heard, intersections between trade and labor. Although I must say that the talk title is perhaps a bit deceptive in one way. And why is that? Why is it deceptive? Will I not be talking about trade and labor? No, I will be. So there is truth in advertising. But the deceptive piece is the word intersections. And as you've just heard so well put from Rizwan, I don't think it's a matter of debate that trade and labor are inextricably linked, and in many ways. So it's incomplete to talk about one without reference to the other. And yet, each of them has developed in its own right to encompass broad areas, bodies of law, some of which do not appear to directly have an impact on the other. But if I were to be more precise, or perhaps more honest, I might have instead titled this Trade's Labor Issues, or Labor's Trade Issues. Even then, seeing them as distinct, it feels disingenuous. And not only that, but in some ways, I think it contributes to the problem, perhaps we should say. That one challenge we face in policy making is accommodating trade principles in labor and labor principles in trade, again, as Rizwan laid out a moment ago. So it's because the two bodies struggle with their interlinkages in the policy space that it would take easily more than the 30 minutes I've been allotted today to try to unravel all of that. I don't purport to do so. But what I do want to do is to tell you what it's like largely where I sit, which is in the United States, and to tell you a bit about what's happening in the United States that implicates both of these overlapping spheres, to then frame those conversations in three rather artificially separate buckets, if you'll permit me to do so, and then to explore throughout that conversation some of the implications of these trends. Now, ordinarily, I wouldn't be quite so US-centric, but I think what's happening in the United States today is having somewhat of a ripple effect that I think is important to capture as we understand these intersections. So in the United States right now, the popular catchphrase for US trade policy is that it is a worker-centered trade policy. Worker-centered trade policy is the tagline or the catchphrase that's used readily by the Biden administration. As you can hear, it puts labor at the center. Now, that's not the first time the phrase has been used. It's not been trademarked by the Biden administration, but it is so much at the forefront of at least the work of our principal trade agency, the US Trade Representative's Office, that it has become the centerpiece across the Biden foreign relations policy as well as the trade policy. So not all agencies use it so much, but with every tool that USTR is deploying, it says it's deploying it for worker-centric purposes. And so that tagline requires some unpacking. It also probably merits some refining. I think the Biden administration is still doing that. It's still in the early days trying to figure out what does it mean to have a worker-centric trade policy? Is it a trade policy for the middle class in the United States, as some people have claimed? I think there are some differences, but it tells you a little bit about how that is being perceived in the United States. So it is a shift in tone from the last administration that didn't put things in those terms, but it hasn't necessarily been a shift in substance across all fronts. Our trade tools, whether in the United States or in other parts of the world, they're rather neutral. That's perhaps you could say they're impersonal. They're impersonal. Right? There is a liberalization component, but they are not constituency dependent. They're not built in the service of any one group in the statutes of the United States. Right? And so the Biden administration has then made this argumentative pivot to frame the tools in service of a particular group for workers. Now, whether that leads to different policy choices than would have otherwise been the case remains to be seen. But let me break this down into what I think are three legs of the stool, so to speak, or three buckets of worker-centered trade policy moves that dominate the thinking, not just in the United States, but also with US allies at present. Okay, so here are the three buckets. The first is workers at home, workers in the United States, an internally focused bucket that cares about domestic work opportunities. It also cares about procedural or administrative means by which to listen better to workers in the United States. So I'll say more about that one in a moment. Workers at home is the first bucket. The second bucket is workers abroad. Now, this could cover a lot of different things, but primarily what we're talking about in that space and what I want to spend a good deal of time on is enforcement under free trade agreements. Now, that could also include negotiation of new agreements, but that's not a major focus right now. Right now, it's all about enforcing the agreements that are in place already. We could also put under the workers abroad heading GSP. You just heard about that, Generalized System of Preferences. We could talk likewise about the WTO in that space. So I'll touch on those as well. But I really want to spend the majority of my time zooming in on one new tool that has recently been used by the US government with a direct impact and implications for global businesses. It is advancing the business and human rights aspect of trade and labor, the corporate social responsibility platform, but through this trade and labor tool. So coming to that shortly. The third bucket I call workers under duress. Workers under duress. And by that I refer to forced labor. Of course, that also involves workers abroad, but I'll tell you why I split that out into its own bucket when we get there. Okay, so those are the three areas: workers at home, workers abroad, workers under duress, as I see it, that are the three main focal points of the US trade policy at present. And they've been reasonably separate in these early months for various reasons, but their interconnections are becoming increasingly interesting. So I hope we'll have a chance to talk about those as well. But for now, let's just take them as they are, sort of bucket by bucket. All right, so the first one, workers at home. I won't spend too much time on this, but key to figuring out how the workers at home policy is going to work turns on what the concept of the worker means. Right? Everyone is theoretically a worker, right? Perhaps save for the very young or the very old, but everyone could be a worker. So are we talking about a specific group of workers? These are a series of questions that I think now, as the current US administration is beginning to really take an active role in the world stage, these are the questions that people are asking. Is the workers at home piece focused on the white male manufacturing worker that was largely the focus of the administration that preceded it? Right? Is it in the service of manufacturing jobs that are key to the livelihoods or had been key to the livelihoods of voters in particular parts of the United States? Or is it something deeper and broader? What about the digital workforce? Does the worker-centered trade policy address those jobs? What about migrant workers? And likewise, I mentioned it has to do with bringing those voices to the table. What does it mean to have the voices heard? And who are the representatives of the workers who are coming to the table? Finally, how do these policies fit together with existing trade rules or with other home-centered policies of the administration, ideas of diversity, equity, and inclusion that we also hear frequently in the United States? So there are a series of questions in this workers at home bucket that I don't think the administration has fully addressed, but which again intends to be the central point of much of the trade policy. And I think a lot of it actually has to do with domestic investments. And that's why we have yet to see how that's going to play out. It might be through Made in America programming, right? Buy American products. certain, in procurement, for example. And we're seeing that come out of the White House, while the trade agency's role is slightly different in that space, right? It's more about making sure that those reshoring programs are consistent with international rules, or perhaps how far the edges of those rules go, the exceptions to those rules, and then socializing these rules with allies. And in a way, I think COVID and the WTO, the World Trade Organization, appellate body, impasse, have provided certain leverage for this administration to be able to roll these programs out with lesser resistance than they may have otherwise faced. But these pieces are still falling into place, and we'll soon see more, I think, on all of that. Last, I might say that I'm not sure all the pieces or the moves of the Biden administration seem to be consistent with prioritizing this. For example, there's a program, a US-based program that intends to provide support for workers who've been affected by trade, and that program has not been renewed as of late. So there's a bit of cognitive dissonance there, but as I said, I think it's too early to tell all the pieces of the worker-centered trade policy for workers at home. But let's turn to where I want to spend most of my time, the workers abroad bucket. Okay, so now in the workers abroad bucket, there's a lot that fits under this heading. And as will be familiar to many of you, the United States, like other developed economies, maintains labor provisions in its trade agreements that are intended to ensure that workers' rights in trading partner countries are protected. It's been that way for some time, and I'll walk us through a little bit of that history. It also, as you heard, we said, uses the preferential trading programs like GSP and others. It also uses executive agreements to address labor issues where it doesn't have a free trade agreement. And so I mentioned the magic word at the moment is enforcement, enforcement, enforcement. And why is that so? Well, it's largely because we're not negotiating new agreements. So enforcement is the way to exact pressure in the labor space for our trade policymakers. The history of labor provisions and trade agreements is centered in the work of the United States. That is, the United States first led the way, in a sense, in putting labor into trade agreements, starting with the North American Free Trade Agreement in the early 1990s. And at that time, negotiators developed a side agreement to the trade agreement. The side agreement focused on labor, called the North American Agreement on Labor Cooperation. They went hand in hand, the trade agreement and the labor cooperation agreement. And if it had worked, if it had lived up to the goals of the negotiators, that agreement might have served as a basis for ensuring Mexican labor rights would be protected, improved. Mexico very much the focus of that rather than Canada, but all three members had committed to adopt and maintain certain labor standards and to effectively enforce their labor laws. It included also an enforcement mechanism that would have allowed for the convening of an arbitral panel to consider where there was a persistent pattern of failure by one of the parties to effectively enforce its occupational safety and health rules, for example, its child labor rules, or certain minimum wage standards. So far as those failures were trade related, that could have been a space for enforcement. It was a reasonably narrow space, and it was never used. It was never used. There was never a panel set up to explore violations of labor laws under the NALC, under that NAFTA side agreement. But there were a number of public communications. There was a vigorous conversation happening between civil society members and the US government in trying to put pressure on Mexico. But again, it never reached the full extent of the enforcement that it could have done. In subsequent agreements, additional labor provisions would follow. And we started to see a pattern of adding labor into the agreement itself, no longer as a side agreement, but actually as part of the free trade agreement itself. And other trading partners would start to follow this lead as well. One milestone in that trajectory was then turning not just the commitments into trade commitments per se, that is not just bringing it into the trade agreement, but then also making it equally enforceable as all the other commercial commitments. That is subjecting the labor provisions of the trade agreement to the same enforcement and remedies as you had for all the other provisions of the trade agreement. Now, has this been working? Has this been working? It is now sort of commonplace that we would have labor in our trade agreements and that they would be enforceable. Have they achieved goals for workers? Well, I think the evidence is fair to say is mixed. There's been one case, one dispute settlement case, not that that's the measure, but many people point to this as a measure. A case involving trade and labor under a US trade agreement. The case was brought by the United States against Guatemala. And in that case, the United States brought forward evidence from workers at different work sites around Guatemala in different sectors that were involved in making products or services that were connected to trade. And they brought all this evidence of dozens, over 100 worker statements from different places to a panel, to the arbitral panel, saying that this was evidence of Guatemala's failure to effectively enforce its labor laws. And indeed, the panel agreed. The panel found that the evidence did confirm that Guatemala was failing to effectively enforce its labor laws. It was the type of thing where workers would say, we've indicated there's a problem here with the safety and health standards at our workplace, and the Guatemalan labor officials are not coming to address them. At multiple instances of that, or an inability to be able to unionize. And so the panel confirmed there was a failure to effectively enforce on the part of Guatemala, but the panel also found that it was not done, that is, the failure of Guatemala was not in a manner affecting trade. In a manner affecting trade. That was, therefore, then Guatemala did not violate the agreement. Right? If those violations were not in a manner affecting trade, it was not a violation of the agreement overall. And so in essence, Guatemala did not have to take any further measures to address what had been the problems that had been found. So many advocates felt that this was insufficient to make a meaningful difference for workers abroad. There have been other efforts among trading partners in the United States to create detailed work plans for labor reform, and that's also underway. But still, there was a fervor, a sense that there's not enough in our labor chapters of trade agreements to deal with what we can see to be problems among our trading partners. And that led to one of the most significant changes in the 30 years of US trade agreements. In the most recent agreement, the United States-Mexico-Canada agreement. So in addition to making some changes to deal with the Guatemala case problem, some of the evidentiary issues that were highlighted there, the USMCA creates a new institution for labor law enforcement. So momentous was this change that a prominent trade practitioner has publicly referred to the USMCA as a labor agreement, not a trade agreement. And here you start to see where we're finding those intersections. Right? It's not that we haven't experimented with new mechanisms in the past, right? You see that in all parts of the world, in new and innovative mechanisms, enforcement mechanisms. But what's different about this change in the USMCA is its direct applicability for businesses. The new institution is called the Rapid Response Mechanism. And this is really sort of hot off the press in my remarks today. It's just that today there have been more reports coming out about how it's being used. What this rapid response mechanism does is it permits the United States to take action against individual companies in Mexico of any nationality, where there is believed to be a denial of workers' rights as it relates to collective bargaining. So put differently, if there is a work site in Mexico where workers are not being able to unionize or some other activity related to collective bargaining, the United States can take action immediately. This is the rapid piece of the rapid response mechanism. As soon as that denial of rights is identified, the United States can delay the processing of shipments of goods from that work site as they try to enter the United States. So what we have now is 2 investigations ongoing under this new tool. The first involves a US company, General Motors. And there's a factory in Mexico that makes trucks, that puts together trucks for General Motors and then ships them to the United States. Popular trucks, pickup trucks that many people drive. And the US government received a tip on a hotline. This actually has a phone line you can call confidentially, anonymously. You call, you say, I think there's a denial of rights happening at this work site in Mexico. And the US then picks that up, investigated, confirmed, yes, we think there is a denial of rights happening at this GM factory. Then that initiates a conversation with Mexico. Mexico then also confirmed there was a denial of rights happening at this work site in Mexico. And together, the two governments came up with a course of remediation to address the problem. This was just issued last week, the end of last week, and now everyone is analyzing and looking, what's the plan? What's the plan? So they're trying to, by the end of the summer, fix this collective bargaining problem at the GM factory. And the company is working with them in doing so. If by the end of the summer, by the end of September, the United States determines that this has not been remediated, then it can stop all those trucks at the border and refuse to let them in for an extended period of time. A second investigation underway is quite similar. It involves an auto parts factory with another US parent company in the auto parts factory in Mexico. Likewise, workers being harassed and terminated for attempting to organize. And this was the subject of a petition that was filed by US labor unions with the US government saying there's a problem here. And that investigation is now underway and could end up in the same path as the truck factory I mentioned a moment ago. So as this new mechanism is being used, there are a few surprises that I think have come to light, and I'll just mention them briefly. One is a number of commentators have thought this would be used more. And here is an easy way. All you do is pick up the phone, you call someone in the US government, you say, there's a problem at this work site, we need to do something. And it hasn't, we've only had these two cases so far. A second surprise has been how cooperative it has been. That is, the Mexican government working closely with the US government, rather than being a sort of punitive or adversarial conversation. It's been much more cooperative in this 1 year that it's now been in use. This all came into force in July of last year. And the third surprise is that USMCA, this agreement, also has still a state-to-state dispute settlement mechanism that doesn't deal just with a particular work site. And the first use of that mechanism has been brought against the United States. That an NGO in Mexico has raised concerns about gender discrimination in the United States toward migrant workers. And so no one really was thinking that this would be the type of tool. No one before has brought a case against the United States under the same tools that the United States is bringing against its trading partners. So that remains a topic of discussion between the two governments. There are other pieces of the agreement that advance support for workers' rights, certain what they call labor value content in the making of automobiles, and a number of other measures. But to the extent more of these cases move forward under this rapid response mechanism, I think I'll just say as an aside, I think it's important to recognize that it's really not about how many cases are brought. Right? Today, this morning, opening up the news, I see commentators saying, oh, we need more cases. Right? That's a very heavy focus of the rhetoric in the United States. But this mechanism, bear in mind, it's intended to deal with places where things are going wrong. And so it may be actually working best if it's never used, right? If it serves as a deterrent. And so it gives me pause when I hear people saying enforcement, because we may want to think about the fact that it actually may be doing its best work when it's not being used at all. But it will be helpful to think about what is the extended, long-lasting impact for workers of these sorts of programs. Is it just that we solve this problem and then walk away? Is this going to be a model for other agreements going forward? That's another question that we continue to think about and ask. And I think that depends on the country. I think it also depends on the scrutiny of these test cases. And so far, we haven't seen a lot of transparency of what's actually happening. But this has been the centerpiece for the last month, if not more, in the United States of the intersection of trade and labor is very much focused on what's happening with Mexico and over concentration really of what's happening in Mexico, perhaps to the detriment of efforts happening in other parts of the world. And Rizwanul mentioned the US termination of Bangladesh's GSP eligibility. Right now, the GSP program entirely is under review, but we will see whether that was brought on an appropriate basis, that is for labor reasons or not. At least there have been continued conversations, as I understand, last March, the United States continuing to engage Bangladesh on these concerns in a meeting that was held in Dhaka last year, as I said. Let me turn then finally to my last bucket, the workers under duress. Forced labor has quickly risen to the top of the agenda, not just within the United States, but also in plurilateral settings. And this move has been underway prior to the Biden administration. So what is happening? Well, first, from here in the United States has upped its enforcement using a tool that it has had on the books for a long time, but declined to readily use since 1930. A tool that allows it to reject at the border. Again, we have the same idea, rejecting products at the border that it believes to have been made with forced labor. So in the last couple of years, the US Customs and Border Protection has really stepped this up, stopped many goods that have been coming in largely from China, goods made in the Xinjiang part of China, and also taking other steps, not just blocking them at the border, but putting certain entities in the Xinjiang region on the entity list, we call it, that basically makes it very difficult for them to do business, and then taking sanction steps as well. So really a full court press, we say, a lot of efforts from many different parts of the US government to deal with this. The United States Trade Representative likewise puts forced labor on every agenda with trading partners to close all markets to these goods, right? That we're only going to be effective in stopping forced labor if it's not just the United States that refuses these goods, but if other trading partners likewise refuse these goods. That's the way to put a stop. It's likewise raised a forced labor issue in the context of fisheries. Many of you may know the fisheries negotiations are ongoing this week as part of the WTO plurilateral engagement on the topic. And now the United States has a proposal regarding forced labor there as well. So a number of countries from all parts of the globe really hooked on that now, not just in fisheries. Okay, please pardon my fishy pun. Still, despite all of the goodwill and activity, because who could be opposed to stopping forced labor? Right? There's no viable position by which you could support forced labor. So there's a lot of goodwill and activity. But despite that, I think there remains quite a bit of divergence among the various stakeholders about how best to make that happen successfully. And really, if you think about it, if we take a step back, the how is the thread running through all of it. For workers at home, for workers abroad, for workers under duress, the idea is good, but we want to help workers who are being forced to work against their will. We want to help workers who are not able to access internationally recognized labor rights, workers who've lost their jobs due to forces related to trade or digitization or automation or whatever the case may be. But the how becomes the question. How are we going to do this consistent with existing rules and tools, or do we need to reimagine those? When it comes to forced labor in particular, you have businesses wondering how can they be sure that their supply chain all the way down is free of forced labor, and therefore they don't get subject to some of these enforcement efforts. And you hear some of them say, well, you can't do this work for workers while losing sight of the burdens on business and making things unworkable. They don't mean that as a shield from liability, but in the spirit of change and improved solutions, it has to be workable. So as a result, one place where I hope we might find some convergence among stakeholders in forced labor is with respect to capacity building, whether at home in our trade enforcement agencies, with our trading partners who are doing this work together with us, and also with companies to facilitate that work. That's where I hope to see more of our political capital being spent across our trading relationships. Finally, let me say a few things now in conclusion, having reviewed our three buckets. It's easy to call any trade policy action worker-centered. I think that message will prevail. The challenge will be, again, the how the many other priorities, including on issues of things like the environment, which are also a priority, how do they fit together? How do they fit together? There are many different groups of workers that are implicated in something like solar power, right? Promoting solar power is a great example where multiple previously siloed areas of trade policy intersect. And so making sure we have the balance right in a way that's beneficial for the constituencies that we care about, which should be so many of them. On the one hand, the United States is doing much more than other countries, but on the other hand, there's so much more work that could be done. Right? It's not the only one thinking about this. You can see the numbers increase over the years. Back in 2005, it was under 20 different trade agreements had labor provisions. Right now, in recent years, we're in the zone of about 100 different trade agreements that include labor provisions. And that's going up in South-South agreements as much as it is among the G7. The European Union recently concluded a case with Korea about labor provisions in Korea, a case under its sustainable development chapters that are growing in popularity in the EU as well. And so we see more labor getting put into agreements, forced labor likewise being high on the agenda in trade dialogues, especially where the focus is on China. But thinking of trade and labor as epistemologically distinct, the sort of decoupling that has occurred between them has proven to be a barrier to some of what I think could be more innovative approaches that we're starting to see that we might otherwise wish to see in this space. And yet thinking of them together also creates new challenges. So there is this ripple effect of prioritizing some of these worker-centered trade ideas throughout the trading system that's going to have both risk and reward. And it just takes us back to the old adage of seeing the trade rules as both the problem and the solution, giving us much more to talk about as we go forward. Thank you so much.
Professor Kathleen, thank you very much for your wonderful talk. For everybody else, the listeners, I would like to request you to please kindly mute your microphones. If you do have any questions, please kindly use the chat box in order to convey the questions, and I will be sure to forward them to Professor Kathleen. Professor Kathleen, we already have certain questions. If you're ready, I would like to ask each one of them. Thank you very much. First question, do you envisage a more aggressive role of labor rights in future US FTAs under the Biden administration?
Great. Well, thank you so much for the question. And again, I'm just so delighted to see so many of us gathered here today for this conversation, even at the late hour as it is in Dhaka. Thank you. As for an aggressive role for labor in future agreements, so a couple thoughts on this. The first is that at the moment, you may know that the Biden administration has not asked Congress for the authority to conclude new trade agreements. So what ordinarily happens in our constitutional system is that Congress has the priority. It is the owner of trade policy. That's what our Constitution prescribes. And so when the executive branch wants to go make trade agreements, it must do so with the permission, so to speak, of the Congress. And so over the years, that permission has clearly been granted, as you've seen and heard. We have 15 different trade agreements that have been negotiated. However, at the moment, that authority has lapsed, as I said. So that creates a pause in trade agreements generally, right? Let alone any with labor provisions. So I just want to make sure that we know about that. And I would say, firstly, before we get into what future agreements might hold, that not having that negotiating authority can be in itself a detriment to labor advances, because it's often through negotiations that some of the greatest gains in labor reform have occurred. It has been in the negotiation of TPP, for example, the Trans-Pacific Partnership Agreement that I know you know well, that in the negotiations of TPP, we had seen some advances in our discussions with trading partners to make reforms, for example, in Vietnam, just to name one. And so without having the prospect of a trade agreement at the end of the tunnel, that can inhibit our ability to do these sorts of negotiations that include labor reform as a carrot for getting the agreement in the end. Okay, but putting that to one side, when we do have authority again to do trade agreements, and it will return, that will happen. It's not a priority now, but it will return. At that point, I think we will continue to see this focus on labor as it has been. It's been a very important issue for the Democratic Party. And it was the Democratic Party that forced this addition of the rapid response mechanism to the USMCA prior to its conclusion. So they had negotiated the entire agreement and signed it, right, and were ready to put it into force. And the Democrats had control of the House and said, no, 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 we don't see enough progress here on labor. And so they added these new parts to it prior to its entry into force. And so long as the Democrats maintain that position, and so long as they maintain some degree of power in either in our Congress or in the executive branch, surely that will be a part of our trade agreements. The question then is, how far will it go? Right? We will continue to see the same labor provisions that we've seen for many years. In fact, there's been a bit of a path dependence in including some of these. It's been hard to break out of them until we get these critical junctures like we saw with USMCA. But when we see that next moment, will it include a rapid response mechanism? Will it include these strong provisions that we've seen in USMCA? I think it depends largely on the partner. Like, for example, one agreement that's been discussed now is with the United Kingdom. It would be very unlikely that a rapid response labor mechanism would be part of an agreement with the United Kingdom. It's not anticipated to be a place where that would be needed. It could be there, but I think that will depend really on who is the partner on the other side. Do we see a place for a tool like that? And if we do, then it's possible that we'll get that in. A lot just depends on the political relationship between the Democrats and the Republicans here. But no doubt there will be labor provisions. The strength is the part that remains to be seen. Thank you.
Thank you very much, Professor. We have a question from one of our students, Monisha Jahan Joya. She asks, if there is a race to the bottom, should countries only trade with those that have similar labor standards?
Another great question. So similar labor standards. So I think part of the idea has been, can we stop that race to the bottom, right? So it's as much as there has felt that, as much as the feeling has been that we have in the past been creating a race to the bottom with trade agreements, and that liberalization of trade more generally has led to this race to the bottom. It's not so much that we want to, I think, harmonize, to the extent the question is, should we find like-minded countries? But the position of the United States, at least, has been, and I think also some of the other G7 countries, has been, let's use our trade tools as an opportunity to stop that, right? Let's use that opportunity to work with our trading partners to reverse the not like-minded views of other places. Now, that's not always possible, right? So in some instances, you say, well, we're not going to work with that country because they're just, the distance is too far. The distance is too far between where they are and where we are, and we're not going to meet in the middle. That is a valid concern, and I think you hear that from some parts of the government, that we're not ever going to have a free trade agreement with that country because of this and other reasons. In those instances, that's when we try to see other tools, right? So I don't want to suggest that the only way to make progress on these issues, to avoid a race to the bottom, is through trade agreements, right? And that we should limit our trade agreements only to those places where we can make that progress. There are other tools, and certainly the U.S. government in the last administration has used them readily. And again, I'm sure you're all aware that we have in the toolkit the ability in the United States to use tariffs, just as most governments do. But here, the executive branch has great latitude to use those other sorts of tools where it finds practices to be unfair, unreasonable, discriminatory, burdensome. And so it's not simply a matter of having to choose among our trading partners who may be like-minded or who may meet us at a certain place, but also to try to then use these other tools to address that race to the bottom through other ways.
Thank you very much, Professor. Our next question. Could you please elaborate on the use of Section 301 for protecting labor rights?
Perfect segue. That's great. That's just what I was talking about. So yes. So for those who don't know, Section 301, what is one of the unilateral tools that I was just mentioning. So let me say a little bit about that. This is a tool that has been in place since 1974 and been used readily over the years, although not so much since around the year 2000, until this last administration, now 4 years ago, began to use the tool primarily against China, but also against certain issues in Vietnam and elsewhere. What does it allow us to do? It does, as I mentioned a moment ago, when the US executive finds that a practice, an act, a policy or practice of a trading partner is discriminatory or burdensome to US commerce, it can take virtually any action within the power of the president to deal with that problem. So it has been suggested, as the question likewise intends, that we use this tool to deal with bad labor practices. And we could be talking about the forced labor type or other types. That idea is floating in the ethos of US trade policy. It is true. So I think it is, I've said this elsewhere, that I think it's possible to use it. I think that the tool absolutely creates the space. That is, the United States could say, here is a labor problem in whatever country that is creating a burden. It's unreasonable, it's discriminatory, and it restricts US commerce. And for that reason, we are going to impose tariffs. And you can pick your product under this tool, right? Any product coming from that country, you can put tariffs on those goods. You can also take other sorts of actions. As I said, it is a wide-ranging tool. We haven't seen that being used yet. And if I just marry up the two last questions in my response here, to say, I think that's because there are other opportunities in the toolkit to deal with labor issues that are more cooperative, right? Which is a part of the shift in tone of this administration to be more cooperative than the last. And that might actually address the problem more holistically. And by that, I mean, is it effective to just tariff certain products? Who wins when you do that? Are you hurting workers more or less? So that's the type of calculus that I imagine is happening among our policymakers today in trying to decide whether Section 301 is the right tool to use for this problem.
Thank you very much, Professor. We have a question. Thank you very much, Professor. Am I being audible here? Thank you very much. We have a question from Mr. Ahmed. He is one of our students. What effect might international labor standards have on workers, companies, and consumers?
A very big question that we probably cannot do justice to in this time. But if you'll permit me with that broad and important question to say a little bit about what I'm hearing in that regard here. If you speak with lawmakers, they often say that the consumers are not complaining so much, right, about goods coming from places where there are labor problems. There's not a big uprising. Yes, there are people who are concerned about forced labor and human slavery and human trafficking and all the bad things that are happening in that regard, and they would agree that that should not be ongoing. But I think there's not a strong platform for among consumers with that at top of mind, right? Rather, they are concerned about getting goods at a lower price. Right? Can they get them? Can they get them fast? Can they get them at a low price? So there is a bit of a disconnect, if you will, between these goals and principles to which they aspire and to which they prescribe. That is that they to which they subscribe. That is that they feel that this shouldn't happen, and yet at the same time they have these demands for the lifestyle that they live. And that is a real struggle, I think, in terms of what policymakers are trying to achieve in this area. And part of the reason why we've seen these other tools being used directed towards forced labor, that again, everybody can get behind. We have to deal with forced labor. We can coordinate on it. We can build on what we have now. And that's something that we need to all do, no matter what you think about cheap goods or availability of goods and so forth. So that, I think, is why that's been the sort of low-hanging fruit, because we can all get behind that. That said, just a final thought on this is, I mentioned there is still a question from businesses about, can we be doing this better in ways that still achieve what consumers are asking for and need, in ways that allow us to do our business? And there's actually a lawsuit now happening in the US court system by one business that says, you said my product was made with forced labor, but I'm telling you it's not, right? So we haven't quite gotten that administrative piece right just yet. And I think it speaks to your question of how do we get all of these constituencies on board to deal with some of these problems, because they do have competing interests.
Thank you, Professor. There's another question from one of our students, former students, Mr. Sharia bin Waris, and this question is particularly from trade law. Usually, the LDC countries do not tend to go to the WTO DSM due to the higher cost of litigation. So what could be the other option for the RTA trading partner for them apart from the mutual consultations?
Another difficult and important question, right? I appreciate that we have some trade experts here. As you've heard, I am a trade lawyer by practice, not by training, actually, but certainly a labor-focused lawyer might raise different questions than the one I've raised today. But given that our tools are on the trade side, as the question suggests, that the difficulties of using these tools are not uniformly felt. I take that point for sure. And that's why I mentioned it was so surprising that to many that Mexico, which of course does not qualify quite in the group that you're suggesting, but is that it would use this against the United States, because that is so rare on the labor side to see that. But apart from that, I think what we're seeing mostly from our LDCs and those that are engaged with the United States on this is the conversation is mostly in the preference programs, right? The preference programs and lobbying to have the preference programs in place to get that back. That conversation here I mentioned is now under renewal GSP, for example, and in that space there are. I think that it will advance. Right? I think GSP will return, but that's why I think LDCs are better positioned to have the conversation with U.S. policymakers, to have the preference programs in place than perhaps to sort of duke it out in dispute settlement. And that's, I'm encouraged by a lot of the cooperation that's been ongoing. I mentioned also these monitoring and action plans. So the United States has not used dispute settlement under its RTAs for labor apart from Guatemala, right? Instead, what it's doing with governments in Honduras, in Peru, in Colombia, just to name a few where we have these in place. What it's doing with those is these long-term cooperative plans. So there is, on the LDC side, there's the preference programs, and on the RTA side, there's these cooperative monitoring and action plans in place for several different governments that are, I think, making a difference. There's a question as to what benchmarks are they putting in place for labor, but there is nevertheless an effort to work closely with them in a way that's not, as I said, not punitive and doesn't require the use of dispute settlement that they can't afford to undertake in any event, whether defensively or offensively.
Thank you very much, Professor. Our next question, what about the alleged forced labor in places like Xinjiang of China? To what extent do you think the WTO regime can be used?
Saquib, could you just repeat that one more time? You cut out a little bit.
Of course. What about the alleged forced labor in places like Xinjiang of China? To what extent do you think the WTO regime would be used or can be used?
Thank you. Okay, so right. So I mentioned a little bit the forced labor efforts that are underway against the practices happening in Xinjiang. That is absolutely the focal point, right? There is no part of the world, no area of the world that is under greater scrutiny right now for forced labor practices than there, and the persecution of Muslim minorities in that area. So almost all of the efforts in the United States are focused on that. Now, the WTO, apart from the fisheries conversation, I'm not seeing a lot of forced labor attention in that realm, in that form. Where it is happening is in other areas, that is among the G7, G20, and beyond, to have more informally. I mentioned getting everybody on the same page and making sure that they're all stopping these goods. And I'm involved in a forced labor working group now that tries to bring together governments, other governments, to say, what types of capacity do you have to know when a good comes to your border? Is it something that's been made with forced labor? Is it something that we can trace back? Not just the final product, of course, but we need to be able to trace back to the origins of the fibers, right? Or the original inputs that are going into your good. Can you do that? And so I actually think we've seen a great deal of innovation in the technology space, right? That, and this is just one of several ways that I think technology provides a great an added means by which we can work on these issues. That is that through some of the innovative apps, through some of the innovative tracing mechanisms that we have with detailed and new technology, companies and countries are now being able to do that work much better. And so that's what our Customs and Border Protection in the United States is doing. It's trying new tracing technologies. It's making sure trading partners have that so that everybody can say, when this shipment comes in here, did it come from Xinjiang? And therefore, do I have a reason to give it greater scrutiny because I can trace back certain things to a certain work site? So that is very much underway in the using what's called the Withhold Release Order under Section 307 of an act that dates to 1930 in the United States, and supplementing the ability of the US government under that act to do more of that work unilaterally, but then also working with trading partners to do that, not so much at the WTO apart from the Fisheries Negotiation, but in other informal and even formal settings, right? Just recently with the US-Mexico-Canada agreement parties, the three parties met, and forced labor was at the top of the agenda with Xinjiang in focus. Now, it's not just the customs efforts that are dealing with the China-Xinjiang problem. It is also the work of our Treasury Department and our Commerce Department that have taken these other steps. I mentioned them very quickly, that they are doing things like putting these entities on these sort of no business lists, right? Making it harder for them to be able to do business with US companies and companies that do business in the United States. There are also sanctions against individual actors in doing that work. So it's really an all of government effort to deal with Xinjiang. The question I think that remains is just how much trading partners can do to support that with us, because it is so top of mind here. And so bringing others up to speed, including LDCs, let's come back to that, right? Including, we don't just want these products to find another market, right? So it's going to take a global effort to put pressure on the region to make sure these places, these goods have nowhere to go. And then on the US side, it's thinking about how we can work together with other China policy areas that are very much on the mind of this administration. That's where there's still, I think, much more to be said, but still a lot of effort happening to deal with the Xinjiang problem outside the WTO mostly, and inside it with respect to the fisheries negotiations.
Thank you very much, Professor. Just one more last question, and we will be done because we're running out of time. The last question, here you go. Do you think that the USMCA labor rights model would work for some other economically less developed countries?
Yes. So this question, thank you for the question again, and for all these wonderful questions. If I haven't thanked them each individually, I'm grateful for all your thoughtfulness. I think it could. I think it could, but I, as I mentioned very briefly in my earlier remarks, a lot depends on how these test cases go, right? And I say that because it's not just a matter of saying, we're going to implement this policy and we're going to stop these goods at the border and you just have to live with it, whatever other country you are. That's just the way we operate. It's not just about that, because so much of the success so far in these early days has been the government working together, starting at a certain threshold and then working together with, frankly, US companies, right? These are US companies that are doing business in Mexico and then bringing those goods back. And so there's a lot of sort of the blend, the perfect blend of opportunity to make changes at these work sites. What remains to be seen is how well will will this mechanism function when it's not this sort of easier ones, right? Ones that we knew to be a problem, ones where there's good faith on the part of the employer to want to try to do more for workers. Those more intractable situations as they arise, that will be, I think, a better litmus test for knowing whether these are effective elsewhere. I won't be surprised if labor advocates seek to use it because it is such a powerful tool. Whether it will come to pass, I at least hope that if it does, it will be in a cooperative fashion, again, rather than an adversarial one where it may be workers and local communities that could be harmed.
Professor Kathleen Claussen, thank you very, very much. It was an absolute pleasure listening to you, and I'm sure all of the participants have thoroughly enjoyed your talk and how you've addressed the questions. For the participants, if you've missed any part of Professor Kathleen's lecture or talk, it will be available on our YouTube channel. Professor Kathleen, thank you very much again, and good night.
Thank you all. Good evening. Take care.